you all got on, I'm probably the worst timekeeper on the court because I get involved in listening to the arguments and I forget to look up at the time. So this is an extended time case though. So each side has 20 minutes. And Mr. Oliver, did you wish to reserve any time?
I'd like 5 minutes for rebuttal, please.
5 minutes. Okay, and I'm here today with Judge Henry Green, the longest serving judge on this court, at least, and with Judge Tony Powell. And I think we're ready to start whenever you're ready to go. We're familiar, as I've said before, we're familiar with the briefs. We're familiar with the facts. So although this is a very fact-intensive case, so I'm sure you all will be arguing some facts, but with that, well, why don't you state your appearances? I've kind of got a little discombobulated here.
All right, Your Honor. James Oliver of Folston Seatkin, counsel for the State of Kansas Department of Revenue.
Okay.
On behalf on the Bicknells, Your Honor, Jay Heydrich of Polsinelli.
Okay, great. Thank you. All right, Mr. Oliver, you can begin.
All right, thank you. May it please the court, it is my privilege and honor to present to you the case for the State of Kansas Department of Revenue. Our argument will be divided into 4 topics to the extent I have time to reach them all. The first is the effect of the district court's errors in stating and applying the burden of proof. Second, the effect of the district court's decision not to apply the legal criteria of Kansas law in determining Mr. Bicknell's domicile. Third, the legal meaning of the term substantial evidence and why the Bicknell's evidence fails to meet that legal standard. And finally, the appropriate disposition of this appeal. One reason for requiring judges in court-tried cases to make separate findings of fact and conclusions of law in a written opinion is to demonstrate that the proper burden of proof was clearly stated and consistently applied. The burden of proof changes outcomes. And this court said in In re Lee, cited in our brief, and in re Bros, a case it cites, that ambiguity or lack of clarity and consistency on the burden of proof requires remand. And when the burden of proof has been placed on the wrong party, putting it right may require judgment as a matter of law for the other party. And that is true here with respect to the district court's determination of Rita Bicknell's domicile. The court said at page 2 of his decision, and I'm quoting, I'm going to be looking at my notes here to make sure I quote the court accurately.
Sure.
It is undisputed that Rita was domiciled in Kansas until at least 2008. He was absolutely correct. Rita's domicile was never an issue, not a disputed fact. But by the time the court reached page 49 of his opinion, he tried to change the facts in the entire course of the proceeding. He said, whether Rita's domicile would pass scrutiny, quote, might seem immaterial, but it is quite relevant. He said, quote, there ought to be some degree of proof that Rita maintained a Kansas residency. And third, this court is not convinced her domicile during the subject time was in Kansas. The court framed the issue as if it were a matter of conflicting presumptions that the department had failed to somehow rebut. He said if one spouse's residency creates a presumption as to the residency of the other, Jean's residency would create a presumption as to Rita's, but not the other way around. This is obviously an incorrect understanding of the presumption that spouses reside together. And more importantly, Rita's domicile wasn't a rebuttable presumption, it was an undisputed fact. Only Jean's domicile was in dispute. And to establish a separate domicile, Jean had the burden of proving that he lived apart from Rita in Florida. Domicile can never be established by the mere intent of the party. Actions speak louder than words. Actions must corroborate and confirm the words. That's the Kansas Supreme Court speaking in Arnett versus Arnett. Jean could not abandon the shared residence in Kansas and establish a new residence in Florida 1,300 miles away merely by thinking a thought about his own intent in his own mind. The proof the law requires of a spouse to establish a separate residence is separation, going to Florida and living there apart from the wife.
Well,
Gene
Mr.
never
Oliver,
actually-
he did a little more than just say, I intend to live in Florida. I mean, there were quite a bit of pieces of information that he was in fact living in Florida with regards to his driver's license, his
Well,
Go ahead.
that's where I disagree, because the courts have treated those self-serving statements. What you have to do if you go down to the Department of Motor Vehicles and say, I live in Florida, is different than an action. It's a statement, a restatement of the same intent that I just said he had in his own mind. He just said it again.
But didn't the statute at one point, that was one of the things it said to look at to determine where someone was domiciled?
It is a potentially relevant fact,
Right.
but it is not an action that constitutes, that is evidence that you've really moved. That requires a separate, living separately, not merely saying you live separately.
Right.
And those actions are treated as self-serving statements, the act of going and getting a license. That's the Peck versus university residence case that says you can't merely announce your intent and then confirm it by registering a car or getting a driver's license.
Right.
That's merely a repetition of your own mental intent.
Let me ask you, and I don't mean to interrupt you obviously outlined a very detailed argument here, and I hate to interrupt you, but is there anything, as I read through the briefs and the record, is there anything wrong with if I realize in the future, in a few years, I may be selling my company and maybe obtaining a large amount of income from that? There's nothing wrong with me deciding to move to a state that doesn't have an income tax, so that when that happens, I don't have to pay tax. Is there anything, I mean, there's kind of this underlying thought I got in reading everything, that there was something inherently fraudulent about that. And I'm trying to figure out what that would be. I could certainly, I'm certainly going to look out for my best interest and what is going to be best for me tax purposes wise. And if it's best for me to reside in Florida when I get this income in, then I can certainly decide to do that, can't I?
Yeah, if you wish to move to Florida, you should move there.
Right.
But you can't merely say you intend to live in Florida and not go there.
Okay.
The court looks at the actions, and Gene did say he had this epiphany or introspection in 2003, where he thought to himself, it'd be nice to be retired in Florida, but then he didn't. His own evidence is that in 2003, he started working on this new big show in Branson, and that was going to take him away 9 months of the year for the 5 years from 2004 till the end of 2008. He also was an executive of major businesses in Kansas, and every year on his tax returns, his 1040 said his occupation from 2003 to 2006 was business executive. He wasn't an executive of anything in Florida. He couldn't go there any more time. There is no record that would establish that he spent more time in Florida after he arrived at that intent than he did before.
Okay.
He didn't move there. And when he says, and he said that he intended to live with Rita, and that's the point I'm making under this argument, is that when spouses live together, I don't care how many times you say on a piece of paper, on a legal document, or in your own testimony that you intend to reside in Florida, what you have to prove to establish a residence separate from your spouse is that you live separately. The law will not accept expressions of intent to live in two different states when you say we reside together. And that's what they said. We don't consider ourselves residents in two different places. We intend to reside together. And if anybody went to Florida more, it was Rita, not Jean. And she said she didn't change her residence to Florida until 2008 because Jean didn't have time to go there. He did not abandon Kansas, but came back, went back to work, and started commuting back and forth from there to Branson. And he could come home on weekends and go to church, see Rita. He could go to board meetings in Pittsburgh. That was headquarters. That's a 2-hour drive. It's like going from Wichita to Kansas to Topeka. So it was what he continued to do indisputably. He doesn't himself say, oh, I went to Florida. He got more and more strong as he went along about how much time he was spending in Missouri. And you can't retire in Florida by starting a new business enterprise, being a theater operator and an entrepreneur in Missouri. So when spouses have a claim to a different domicile without proof, they have separated and live apart, as a matter of law, the two domiciles are at best a tie. Gene had the burden of proving that he moved to Florida and lived alone without Rita. They could not meet that burden of proof. Could not be done. And that's because the law doesn't allow it. Now,
I know your next issue you wanted to get into, you said was this, I think you said at the beginning, was this issue of BOTA, what is meant by a de novo appeal from BOTA and what.
Well, I had intended to discuss next findings and heightened burdens and fraud. I mean, I would like to talk about these amendments that were made to change the time of trial, but they take so much time away from the merits.
Okay, well, I have a question about that.
Yeah, okay.
I have a question I want to be sure and ask you.
I will
So
defer.
one of the issues though that's been raised is, what is meant by a de novo trial in the district court, and was the district court limited to the evidence that was presented to BOTA? Because the district court judge wouldn't accept the evidence as presented to BOTA. He required everything to be presented anew. And my question for you is, do you allege that there was additional evidence presented before the district court that was not presented to BOTA? Do you understand what I'm saying? But if the argument is that the district court can only hear evidence that BOTA heard, was there evidence that the district court heard that BOTA didn't hear?
Generally, no. The evidence was somewhat different. And so if you read what happened in BOTA, it would conflict with and impair the credibility of what was said in this trial. But what is important in my mind is whether the issues are the same and whether the court can review the record. It's part of the evidence.
Oh,
When the statutes were amended,
that you got before BOTA, were there items that you got considered before BOTA that you did not get considered before the district court? I'm trying to think, how were you prejudiced by that?
Well, one thing, when the court says Rita's residence is a disputed fact, I mean, there's a ton of evidence in the BOTA proceedings where she talked about her own residence, that she was a Kansas lawyer, that she understood what residence meant.
And did she testify in the district court case?
She testified in the district court case, but again, her residence wasn't an issue. And that was not an issue to repeat, but the evidence is there and she should be bound. There are admissions she's made before. And I'm just pointing out that the court shouldn't be able to relieve parties of admissions, create new issues. What you should do is read the statutes, and the court refused to do that. You have to exhaust administrative remedies. You have to preserve issues. You can't just show up and turn your back on the Board of Tax Appeals and not participate. You can't purposely antagonize them and say, well, I'll go up to district court and this is all new. It counts. And so sometimes issues of fact, when you present new evidence, that requires a ruling on admissibility. That does create a new issue if you offer new evidence. And the district
You've
court
only
was
got
not
a
interested
few
in
minutes
hearing
left
about
in your
that.
first 15, and I know this goes awfully fast, but I also know that our panelists like to ask questions. So did either of the Judge Powell or Judge Green, did you have any questions before he finishes up his first part here?
Well, I don't want to interrupt Mr. Oliver's presentation, but I know a part of it in reading his brief, he talked about the trial court being biased. I'd like you to hit some high points about why you believe the trial court was biased, especially in this journal entry that the trial court wrote.
Well, when the trial court says arbitrarily and capriciously that he can raise new issues and change Rita's domicile, that's a bit arbitrary and suggests bias. When he says he's stepping out of his role as a judge and calling out the Department of Revenue and BOTA and CODA with no evidence in the record to suggest they've engaged in any improper conduct, that certainly suggests arbitrary and capricious action. When he changes the burden of proof, and this is what I really wanted to get to, because he makes a point of saying, this is not a situation where the evidence supports a design or plan on the part of Gene to purposely deprive the state of Kansas of revenue to which they were rightfully entitled. To borrow a phrase from Equity, his hands are clean. If the contrary were true, he says, the court would have been much more likely to construe evidence in favor of Kador and against Gene when appropriate. He is in effect saying we could have prevailed on the evidence, but we didn't meet a heightened burden of proof of proving fraud or unclean hands, which if that's an issue, it's clear and convincing evidence. And this jumbling of legal theories and burdens is clearly prejudicial error that requires reversal. And the people of Kansas were entitled to the presumption that their public officials, the administrative agencies, acted properly, that they decided the case correctly, and to have the burden of proof imposed on the taxpayer. And because Gene was claiming to have moved from a state with high taxes, a high burden, to a state with low taxes and low burdens, the substantive law cases say that that kind of evidence should be viewed with some skepticism or suspicion and may have little weight or credibility. And so there wasn't a heightened burden on the Department of Revenue. There was a burden on the Bicknells to demonstrate that the intent was bona fide for reasons other than saving on taxes. And he actually identified only two reasons for desiring to reside in Florida. One was warm weather and sunsets on the beach.
Good enough
The
reason.
other has to be taxes. You can do the first one with, if you're a winter resident, a snowbird, and millions of people do it. And the reason to prefer Florida as a resident, when you say this test is where is your home, where is your family, where's your business, where do you spend your time, where do you go to church, where are your friends? It's all Kansas. The reason to go to Florida is not to have to pay taxes. And Gene was very conscious and said as early as 1999 that he would have to consider selling National Pizza Company before he retired. None of his family was involved in it. There's no feasible way shown that you could keep it in light of the estate tax. It would have to be sold to pay the taxes if Gene died. And it made sense for him to sell it. The question was just timing. And even without regard to timing, it's better not to pay income tax than to pay income tax. It is a benefit, whether it's $1 or 400 or 40 million. And so the court really went after the Department of Revenue and unfairly. I mean, even the woman who worked at the Driver's License Bureau in Pittsburgh, the court said was unreliable because she worked for the Department of Revenue and met with the Department of Revenue's counsel.
We
even
don't
though all she
reweigh
was saying was that Gene came in and applied for a driver's license like everybody else and said he was a resident.
Mr. Oliver, we don't reweigh the evidence, though. I mean, it's clear that Judge Smith found some people credible and some people not credible. We don't reweigh that in reviewing this case.
I agree, Your Honor, and I'm not trying to argue credibility. I'm responding to Judge Green's question about the bias and prejudice against the Department of Revenue, and it was from top to bottom, even just the ordinary nice woman who works at the Department of Motor Vehicles biased against her just because she worked for the Department of Revenue. So I thought it was responsive to that question.
Okay. Any other questions? Bicknell or Judge Green?
Okay, could I talk about the
I have a
substantive
couple
law?
more that wait, and I think we're going to use up all your time here. One of the other issues is how, again, back to this trial de novo and how do we interpret what this trial de novo means, and there is no doubt, and I share Judge Green's concern about a statement you made in your reply brief where you say, in conclusion, you allege favoritism by the district judge to a wealthy, influential man. And that's a pretty spurious statement to make against a judge unless you have some evidence to support that. And I'm just making that comment. And you can respond to that in a minute. But my other comment has to do with, in deciding whether this is a trial de novo and what that means, there's no doubt that the legislature, at least from the evidence that was presented in the record, that the legislature showed Mr. Bicknell favoritism by overriding a veto and adopting a law that they knew would benefit Mr. Bicknell if he were to win in this case. So should we consider that legislative history in interpreting what is meant in this case by a trial de novo? Because certainly this case was front and center when that law was changed.
Yes, it was. And the legislative history is not relevant until you first read the statutes. This is all about what's the extent of implied repeal. Mm-hmm. And I agree, it's a trial de novo in that the judge has the right to refine facts without deference to the agency's findings. But there are other statutes it's still judicial review. The standard of review still requires you to consider all the evidence, including that's for or that detracts from a point. You can't just arbitrarily say the Department of Revenue has no evidence at all when we've got stacks and stacks of evidence, objective evidence, that isn't dependent on opinion. And so as far as whether the trial judge did the right thing, and I think this is important too for the issue of bias by the trial judge. What I think happened here, I mean, there's been a lot of research done by people about motivated cognition. Dan Kahan at Yale is one of the people who's studied this a lot, and they say that people can unknowingly, if they're motivated cognitively to perceive the facts the way they want, they can't even do math right. If they are people that know math facts, they will not be able to do math. That power of motivated cognition is so strong. And when you get to things like what the court said about Rita's residence, what he said about the law not applying to Gene because he was likely oblivious and we couldn't apply the lens of legal criteria to Gene. I mean, that is motivated cognition. It may be unconscious on the part of the judge, but the result is an arbitrary and capricious decision. And I tried to explain very carefully in our reply brief that that's what we're talking about. This decision is objectively arbitrary and capricious.
Okay, thank you. I'll give you about 1 minute to wrap up.
Okay, one thing, in the case of the state of Phillips, the court said that conduct by a party has consequences and the actor must abide by those consequences whether intended or not. And the law of Kansas requires that the primary intention of a domicile of choice is the intention to make a home rather than the intention to make a domicile. And the court just really was all over the map. The decision was internally inconsistent. It does not contain a statement, a separate statement of facts. If you had to copy what part of that decision is a statement of facts for purposes of your opinion, you can't find it. It's all commingled opinions, some facts, no statement of what actually happened here. What actually happened here is Gene said he was going to move to Florida. He said he'd given companies away to Marty. He said he'd put Marty in control. None of that was true at all. It was uncontroverted that the documents did not support it, and Marty didn't have power of attorney until after he sold National Pizza Company. Gene stayed in control. He was busy 70, 80% of his time in Kansas and Missouri, not Florida. By his own testimony, he did not change his residence to Florida. Thank you.
Okay, thank you. All right, Mr. Heydrich.
Thank you, Chief Judge. Again, Jay Heydrich on behalf of the Bicknells, and as the court is probably aware, Rita Bicknell recently passed, and so in addition to Mr. Bicknell, he is also the personal representative of the estate of Mrs. Bicknell as well. Mm-hmm. I do have a presentation, and I'll outline kind of my roadmap, but of course, welcome any questions from the court as they come up. So please interrupt me if you choose to. My goal is to make sure I get your questions answered more so than just listening to me talk today. We've all heard the saying that if the facts are against you, then you attack the law. If both the law and the facts are against you, then you should attack the judge. And of course, that's not necessarily a wise or successful strategy, but sometimes it's all you can do. And that is all the department can do here. Attack the judge because the law and the facts clearly are not on its side. Mr. Bicknell repeatedly stated that by 2003, he was a Florida resident. The department simply says his statements aren't credible. Over 10 witnesses gave corroborating testimony supporting Mr. Bicknell's intentions about how he was not around Kansas anymore, made completely off-the-cuff comments about wanting to move to Florida, his desire to become a Florida resident, step away from work. The department says each of those witnesses, you can't believe a single word any of them say. Undisputed evidence, such as voting records, tax return, estate planning documents, driver's license, countless other exhibits support Mr. Bicknell's assertion that he intended to become a Florida resident and was by 2003. The department says, again, these are not credible. You can't rely on any of these things. And when a respected judge with decades on the bench, appointed by our Supreme Court specifically to this case, looks at all the evidence and finds against the department says he's biased. This wasn't motivated cognition or anything like that. He wasn't biased against the department. He simply saw what any unbiased trier of fact would see, that Mr. Bicknell was a Florida resident for tax years 2005 and 2006, and it wasn't even a close call. He didn't attack the driver's license witness. He just didn't believe her. And that's all it comes down to with the department's evidence. Nothing more than that. I'm going to start my presentation with four different areas. They kind of go over Mr. Oliver's points, but I'm going to start with the burden of proof and then move to the de novo scope of 2426, and then address the venue considerations. And if the court has any questions about the department's argument to reinstate the CODA order from 5 years ago, I'll welcome any questions on that if we have time. But it's clear the district court did not impose a burden of proof on the department. On page 17 of his opinion outlining the applicable law, Judge Smith quotes a passage stating that the burden is on the party asserting a change of domicile. That was Mr. Bicknell here. On page 33 of his opinion, when addressing Mr. Bicknell's prior domicile as one factor of consideration, Judge Smith stated, as to the very generic, and I quote, as to the very generic concept, it is true that Gene had a prior domicile, that being Kansas. It is then incumbent upon Gene to demonstrate that he had met the necessary criteria as established by his actions and statements to establish a domicile of his choosing. As stated above, the court is convinced by clear evidence that those criteria have been met, thus factor weighs heavily in Gene's favor, once all the evidence is considered. The court clearly put the burden on Gene to establish that he changed his domicile.
But let me ask you this question. When the court said that the department produced no witnesses who contradicted this testimony of Gene's friends and, and relatives and so forth and family, and then the trial court later went on and saying, it said, if this was that Gene continued to live in Pittsburgh, it seems likely that in the last 10 years, a witness would develop to testify this is a sham. Let me go on and read. It is prudent to resist total reliance on the absence of evidence for the proof of anything. Court then ends saying, still, this is a deafening silence. This is almost saying that the Kansas Department of Revenue needed to come up with some evidence, negative proof, for me to go ahead and believe that to overrule what Gene has said that he moved to Florida. It seems like a burden shifting. Explain to me why it's not.
Yeah, thank you, Judge Green. That's a great question. It's not a burden shifting as much as it is a response to, when you read that quote in context, a response to the weight of evidence that Gene had already put on. And so if you go to our scales of justice, and Gene has the burden of proof to move those scales, and that was his burden of proof, he took it on. When you have 10 witnesses that go forward and over 10 witnesses and produce that evidence and that testimony and talk about Gene's intentions, he wasn't around. He had talked about wanting to move to Florida. He said, I'm tired of the grind. I'm going to get out of it. That evidence shifts the scales. And if the court finds that relevant and credible evidence, it shifts the scales. So what does the department need to do then? It has to rebut that evidence. If it doesn't rebut that evidence, then that evidence is unrebutted and it shifts the scales. It doesn't mean that the department has to have a burden of proof, but the department has to have something that contradicts the credible proof that the court found Mr. Bicknell put forward. So the district court wasn't saying the department has to come forth and put evidence on to show that Gene was a resident of Kansas. That would be a shifting of the burden of proof. What the court said was, I got 12 people who are respected people of the community, who are credible, who testified to their personal knowledge as to what Gene said. And the department has been litigating this case for 10 years, and they haven't been able to find a single witness that can counter what these people said. It didn't shift the burden of proof. It just said that Gene's evidence weighed heavily in Gene's favor, which is the tone of that evidence throughout. And the comment about this silence is deafening goes to that weight of evidence and the credibility that the judge assigned to it. It wasn't a burden shifting. It was simply, this is believable, and the department hasn't said anything to make me not believe it.
Thank you.
Does anyone have any other questions? All right. The majority of the department's brief, and as the majority of the department's oral argument thus far, has been related to facts, arguing that these facts should be considered, or these facts show that Gene was Florida. Gene wasn't a resident because of these facts. But as Chief Judge Arnoldberger pointed out, we don't reweigh the evidence here. This court does not reweigh evidence. It doesn't make credibility determinations. the court's sole role here is to determine whether or not substantial evidence supports the district court's decision. And substantial evidence clearly exists from the district court's opinion. Judge Arnoldberger, as you pointed out, he did do more than just go get a driver's license. And the district court laid out all of those facts, such as changing his estate documents, owning a home, opening a bank account, statements made to witnesses and friends. I'm not going to go through all of it, but the district court's decision is amply supported by factual evidence to support his conclusions.
What about the district court as far as, following, saying out statements of facts and conclusions of law separately? I read the whole order of the court, and I never really saw how the statements of facts were separated out and then going to the conclusions of law. Is it there? Am I missing something?
Yes, I think it is. When you talk about when the district court's decision starts out and discusses about how particularly Gene's domicile from the 1999 through the 2000 period, going back and forth, and the steps that he took about convalescing with his wife in Florida. It talks about voting records. It talks about statements of witnesses who supported his record. Those are all laid out in the district court's opinion. And there is no requirement that the district court weigh every fact and create a laundry list of every fact that was presented to it. The requirement is only that the decision have sufficient evidence to allow this court to determine whether or not substantial evidence exists. And in the district court decision, he cites to voting records, he cites to his driver's license. He goes through all those issues. And it's important to note that there's no contest, there's no dispute that those facts exist. The department doesn't dispute that he never voted in Kansas after 2003. The department doesn't dispute that he voted in Florida from 2003 forward. The department doesn't dispute these facts. And so when Judge Smith cites to those and talks about those in his opinion, that is substantial evidence to support his decision.
You can proceed.
Going forward with the de novo review scope of 2426, it is clear from reading the statute and from the legislative history that the legislature intended this to be a complete de novo redo. You can see that by not only how the court or the legislature added the words "an evidentiary hearing," where law and fact will be determined anew, but also modifying 77-618, which governed how 77-618 limits the scope of review to the agency record. And subsection F of that statute in 2016 was expressly amended to say that income tax or tax cases will be reviewed according to the de novo standard of 2426. Moreover, the statute of 2426 itself talks about an exception to the KJRA. It says appeals will be subject to the KJRA, except that income tax appeals will be determined by a de novo hearing to the district court. When you look at the legislative history, as Judge Smith outlined in his opinion, that absolutely supports that further. And then when you look at just how practically how this works with the statutory interplay, BOTA is allowed to issue a summary decision. As we learned in what the parties have referred to in Bicknell 2, the administrative agency is required to issue a decision that a reviewing court can determine whether or not substantial evidence meets it. There is, what Judge Smith said in his opinion was that this has to be a de novo review, a whole new determination of issues, because there could be no substantial review of substantial evidence from a summary opinion. And that's also why the statute requires that if a summary opinion is going to go up to this court for review from BOTA, there has to be a full and complete opinion before that happens. Why is that? Because there has to be a sufficient record made. If a taxpayer is allowed to have a de novo review before the district court on a summary opinion, the only allowable way to review that would be a new trial de novo, meaning a complete do-over, as we put in our brief. That's the clear intent of the legislative history. That's the clear intent of reading the statute. And the department itself has admitted that the de novo review, the evidentiary hearing, allows for oral testimony. Well, how do you have oral testimony to determine credibility of witnesses if witnesses have to just read their transcript from the lower proceedings? It doesn't make, the department's argument doesn't make sense factually, legally, or logically. And going to your question earlier, Judge Arnoldberger, as well, the department hasn't cited a single piece of evidence that it was precluded from presenting, or a single piece of evidence that was admitted that shouldn't have been admitted. And this is really telling because as part of our briefing to the lower court, we submitted a chart of comparison that compared the evidence that was submitted to BOTA and the evidence that was submitted to the district court. We talked about that in our opening brief here as well. Despite having that chart, despite hearing those arguments multiple times, the department still has not brought to you a single instance, piece of evidence that it claims was admitted or kept out that was prejudicial to it. Instead, it just says the instances are too numerable to list. Well, I submit to you that there is a strong difference between not being able to list everything and not listing a single thing. The fact is, there's nothing that the department can show that was prejudicial error. Next, and finally, I want to address venue in this case. The department has raised the issue of venue. Venue was proper in this case. 77609 talks that venue is proper in any county where the order was issued or where the order is effective. And case law has interpreted that to mean, where is it felt? Where is the effect of the order felt? And we've cited the Rodenberg case and the Carnes case and the Meinfeld case are kind of the three main cases addressing the statute. And it is important to note that at the time the Bicknells filed their petition for judicial review, the department contended that the Bicknells were Florida residents. To this day, the department has not conceded that the Bicknells ever moved to Florida, nor could it, because if the Bicknells, if the department contends that having family in Pittsburgh and a house in Pittsburgh and a personal assistant in Pittsburgh is sufficient to justify Kansas residency for 05 and 06, then if it ever contends that Gene moved to Florida later on and still have those factors, its case would fall apart. So it still contends to this day that the Bicknells are Kansas residents. Why is that important? Well, there is currently a tax appeal for the 07 and 08 tax years that the department that has stayed before BOTA. The department will undoubtedly contend that the 05-06 BOTA decision creates a presumption of continuing Kansas residency to the Bicknells that would be effective in that for that appeal. So that order was clearly effective and impacted the Bicknells in Crawford County. Additionally, the department's brief goes forward to say that when Mr. Bicknell if Mr. Bicknell chooses to move to Florida, he has to forgo meetings with friends and family. He has to forgo sleepovers with the grandkids. He can't see any of his people in Crawford County anymore. None of his friends can't go back for businesses. You know, as Gene said at the original CODA trial, he said, I just wanted to move from Kansas. I didn't want to divorce it. But apparently that's what the department says has to happen. When you choose a grandparent, when a grandparent has to choose whether or not to face tax consequences or have a sleepover with their grandchild, as the department says he must do, that is effective in that county. And in particular, you
have about 2 minutes.
Thank you. And particularly the Carnes case that we cited as to venue, he wasn't even a resident of Pottawatomie County. It just said that he worked there and it was therefore effective there.
And what's the result if we find there was no venue?
There is no, if venue was improper, the result is still harmless error. Judge Smith was appointed by the Kansas Supreme Court. The only difference is that the courtroom would have been different. That's all. It was not a Crawford County judge. It was not a Crawford County jury. The only difference is that it would have been a different courtroom. As the Rodenberg case says, that's insufficient. I'm a little bit unique in that I'm the only attorney who on this case who has been involved with this case since its inception. 10 plus years I've been working on this case. And I'll tell you that in getting to know Gene in the decade past, he just wants one thing. He just wants fair trial. He wants someone to listen to the evidence, fairly apply it, and come to an unbiased conclusion. That's exactly what the district court did here. And as a matter of policy, we should encourage people like Gene Bicknell. We should encourage people, self-made people who build companies, help a state, and when they choose to leave, we should let them leave, not shake them out on their way out the door. And that is something that as a tax policy, we should encourage people to hold them. They should pay the taxes they owe, but we should not hold them to this amorphous standard of, well, you said you retired, but you didn't, or you did this. We should just give them fairness in all aspects. And that's all Mr. Bicknell asked for here. Thank you. I appreciate your time, and I'll take any questions the panel has.
Any questions from the panel? Okay, thank you very much. Mr. Oliver, I'll give you your 5 minutes.
All right, thank you. The Department of Revenue obviously only wants a fair trial as well. And this case has been pursued by diligent public service servants through 3 administrations because it is, in our opinion, absolutely obvious that Gene did not move to Florida. And when Mr. Heydrich talks about what the evidence is, all he talks about is a list of documents where Gene said, I intend to reside in Florida. He never talked about physical presence, transferring his physical presence from Kansas to Florida. We don't argue that he can't come and visit his grandchildren, but that is legitimate evidence of motive to choose Kansas as the domicile and home. That's what is a home, the place to which you return to see your family, your friends, to take care of your business, your property, like Pitts Plastics that produced $25 million in distributions to Gene in the years in question, which would buy him 5 beach houses in Florida. The $440 million gain he got on NPC would buy 88 more houses in Florida. He had strong motives to be in Kansas, and he was in Kansas. And he testified that at trial that in 2006, the year in which he, just 2 months before he sold NPC, he said he and Rita did not live apart in separate residences, and he could not say otherwise because it was not true. And if you want to talk about what's a new issue that isn't fair, it's trying to say, well, we're going to move Rita to Florida because Gene didn't go to Florida, so we're going to suspend the KJRA and say you didn't have to raise that issue in any of the administrative proceedings. You didn't have to have it in any pretrial order. We're going to put the burden of proof on the Department of Revenue, and we're going to find that Rita, a Kansas lawyer, doesn't know her own residence because it puts Gene, as a matter of law, in Kansas, residing with his spouse. That's changing the rules. And when the court says, I'm not going to apply the legal criteria relevant to Gene's historical activity, i.e., did he make a home? Did he transfer his presence to Florida? Or did he just start creating documents to say he was in Florida? There is no dispute among his friend witnesses They don't know whether he was in Florida because they all resided in Kansas at the relevant time. To get witnesses from Florida to have somebody to show up and say, this is a sham, well, nobody in Kansas knew he had moved to Florida. They all admitted they did not know where Gene spent his time. They
So
knew that
one
he
of the
intended to move there someday.
Okay, so
when he
one of the
retired.
keys, Mr. Oliver, then is the fact that the internal inconsistency as to how can he say that Rita and I never lived apart,
Mhm.
yet stipulate that, yet everyone agrees that Rita was a Kansas resident until 2008.
Mhm.
How do you how do you make those? There's no way to make those two statements consistent, right?
Correct. It's at best a tie when spouses say we live together, but we have different residences. Unless you can prove you lived apart, you can't meet the burden of proof. It's a tie at best as a matter of law. And the burden is preponderance. And what is substantial evidence does depend on personal knowledge. The people who would have had personal knowledge whether Gene was in Florida would have been somebody, his next door neighbor in Florida, maybe the person who saw him out to get the mail every day, the person who saw him at the beach all summer, the person who saw him at the grocery store buying a Halloween pumpkin, the person who saw him at church every Sunday. There are no such witnesses because he wasn't there. And the tumult, the supposed question of fact, I'm not arguing facts. Gene's the fact arguer. He had all these statements that he had filled out that were inconsistent about where he lived. He created his own tumult over what the facts were about whether he could even keep his statements of intent straight. And his own staff said they did not know when he moved to Florida, and they kept saying he lived in Kansas. His own lawyer kept filing papers saying he lived in Kansas. Nobody knew he moved to Florida. He didn't tell anyone. And I think he was happy to be the man in charge in Kansas and not tell them because it didn't happen anyway. So that's the case. And if we have to have a remand, it should go to Shawnee County where there are regular district judges available to hear the case. And it shouldn't go to Crawford County because the venue is determined at the date of the appeal. And at that date, there may have been some old case pending, but the statute
how were you harmed?
is long expired.
If we say that venue was improper in Crawford County, what do you say to Mr. Heydrich's argument that it's harmless because all it means is a different judge would hear the case? What's the significance of that?
Well, this law is that venue statutes are mandatory. You can only lay venue and give a court power to decide a case. This is not a discretionary venue issue. It's if he lives in Florida, the opinion does not have effect. We could rely on his own pleadings and say, they're affirmatively saying he lives in Florida, we'll agree for purposes of this motion at a different date. And if there was no power to hear the case in Florida, and we should, or in Pittsburgh, I'm sorry, we should have had a Topeka judge, and we're still entitled to a Shawnee County district judge.
And you believe that you can establish beyond a reasonable doubt that would give you a different result? I mean, I'm not
saying it would give you a different result. I am saying that it would give you a fair trial and a judge with the power to decide the case rather than a judge who is wrongfully appointed to a court who is appointed to a venue. He becomes a Crawford County district judge and he had no power to proceed. That's the point. Okay.
You want this thing to be a complete redo in Shawnee County?
If we have to retry it, and I don't think there's any way you can affirm it because, the opinion, when you've got questions about the burden of proof.
Venue is pretty much a preliminary step. So before we get to anything else, we'd have to decide if venue is proper. So if we decide venue is improper, not harmless error, we go through all of this again in Shawnee County.
Mm-hmm.
Yes?
Yep.
That's what you're seeking. Okay.
I am seeking a judgment as a matter of law because they failed to meet their burden of proof because it's established.
But we don't get to that if venue was wrong, right? We've got to address the venue issue first.
That was established in the first trial and it's not disputed. It's a summary judgment issue.
Okay.
I mean, well, we can move for summary judgment on remand, I guess. All right. It's a hard question,
Okay. Yeah.
but I appreciate your attention and we do thank you on behalf of the Kansas Department of Revenue and the people of Kansas.
Any other questions from the panel? No?
No, I have none.
Okay. Thank you very much. Very interesting case, and we will get an opinion out as soon as possible.
Okay.
Thank you,
Thank
Your
you.
Honor.